Page number 10, still number 28 to 34. Page 11, still number 35 to 40. Page 12, still number 41 to 48. Page 30, still number 49 to 54.
51, please. Janardhan Reddy, 1 week's time.
At request of appellate, release next week.
Page number 40.
53, man.
At request of learned counsel for
Respondent. I'm filing this university wakalat mela.
which respondent? Which respondent?
Claimants, respondent claimants.
Respondent claimant released after summer vacation.
Page 40, still number 48.
Serial number 1 ballot IFA for the appellant KSRTC. The office objection is
Yes,
that the office objection is with regard to signature melody is not forthcoming in the judgment. At page number 16 of the judgment,
what is not
by both
forthcoming?
side melody, it seems the learned judge, MACT member has not put the signature.
What is not forthcoming?
Signature of the MACT member
Where?
at the typed page number 16 of the judgment. Last page, annexure ಅದಕ್ಕೆ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. 15ನೇ ಪೇಜ್ ವರೆಗೂ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರು. 16 ಮೋಸ್ಟ್ಲಿ ಇದು 15ಕ್ಕೆ ಕೊನೆ ಆಗುತ್ತೆ ಅಂತ ಅನ್ಕೊಂಡು ಬಹುಶಃ ಮಾಡಲಿಕ್ಕಿಲ್ಲ. These objections may be overruled. And Malad, subject to deposit of 50% Malad, stay may kindly be granted. Before the tribunal Malad will deposit and let them withdraw the amount also.
Heard learned counsel for the appellate. Do notice to the respondents. Pending consideration of IA number 1 for delay. IA number 2 for stay is taken up for consideration by imposing certain conditions. There shall be stay of operation and execution. Judgment and award dated 13/10/23. In MVC 21 of 23, subject to the condition, the appellant corporation deposits
50% of the
50% of the award amount
with
Before the-
interest
before the tribunal
before the tribunal.
within 4 weeks from today. On such deposit, the amount shall be kept in a fixed deposit for a period of 6 months or
Malad,
otherwise ordered.
This appeal is connected with the claimant's appeal is there, Malad. MFA 426 of 2024.
Call along with MFA
426 of 2024. 426 of 2024.
Yes.
Your Lordship, there are minor 2 corrections. I may kindly be permitted to carry on to the needful.
Learned
And
counsel
meanwhile,
for
I'm
the appellant
praying for the
permitted
stay of
to carry out the corrections during course of the day. What are those objections?
a small correction, that is the index has to be filled and 1 index page has been extra tied along
Take it
with.
out. We'll call
I'll
it
just do
later.
it. And stay may kindly be granted, Your Lordship.
Huh?
Yes.
Next. 2 weeks time granted to comply.
I have tried 2 objections.
Huh?
A week's time may be granted.
Withdrawal of the amount, I filed IA for withdrawal of the amount.
You are owner.
ma'am.
You're for,
I'm the owner of it.
have you deposited the amount?
I have deposited the amount
Where?
in Davangere.
Where is the acknowledgement?
So I think that's not filed it.
Madidira?
What is?
I'll permit him to withdraw. What is the challenge?
there is a serious dispute because the petition, the disease who died, he was not, he did not die on the basis of the accident because there is no any discharge
filed
summary or
objection?
anything else.
Have you filed
is-
objections?
No, my lord.
For that, that's
No,
what I filed objections because of power fluctuation, my company has gone out of order.
They have not
Each time
taken
may
the
be given.
contention before the tribunal, my lord.
Non-filing of amended cost title. ಆಗಿದೆಯಾ? All right, a week's time is granted.
Week's time, please.
Kindly be given, my lord.
Right. Released on 25th.
Much obliged.
Response number 5, 1 month.
Week's time to comply. Same.
Notice to, notice to R2, my lord, maybe dispensed to. Serial number 6.
I am for respond number 3, my lord.
Notice to R2 is dispensed at the risk of appellant. Memo is
Call for
accepted.
TCR, my lord. Required TCR.
TCR or TCR.
Please, my lord. Much obliged.
Deposit ಮಾಡಿದೆ.
ಮಾಡಿದ್ದೀರಾ? Counsel for the appellant submits the amount has been deposited as per the order of this court. Yes, what about withdrawal?
Immediately after vacation, it may be disposed of, my lord.
What about withdrawal?
Withdrawal, false implication of the vehicle. After 6 months, they have made MLC, my lord. MLC, as per MLC, it's a self fall. After 6 months ಮಾಡಿದ್ದಾರೆ.
It released next week.
After vacation.
Hearing for appellant in this case, Your Honor. Kindly dispensation to R1.
Notice
is
to
served,
R1
Your
is
Honor.
dispensed.
Kindly directed to notice to
R2.
BC Shivanegoda.
United India Insurance,
BC Shivanegoda is appear.
Learned Counsel BC Shivannagowda is directed to take notice for R2 registry to show his name in the cost list, copies to be furnished. R2. Weeks time granted to take steps. Notice to R2 dispensed.
R2 is the owner of the vehicle. Notice to R2 kindly be dispensed. Lordship, kindly call for the TCR.
Secure TCR.
Much.
Insurance company. Deposit already is made, lots. On, the acknowledgement is also filed on 18/11/2020.
Counsel for the appellant submits that he has deposited the
Award amount as well as the interest.
before the,
Award amount as well as the interest
where have you deposited?
before the trial.
Before the trial
Tribunal.
court. Registry to verify.
Stay
Notice
may
is not
kindly be
ordered?
granted.
Huh?
Stay may kindly be granted.
Third learned counsel for the appellant. Huh? What is the balance amount you have deposited?
Lots, the award amount was 7,46,000. We've deposited 9,57,758. About 2 lakhs is the interest. 2,10,000 is
Have
the,
you deposited the remaining balance amount?
the entire award as well as the interest is deposited.
How much?
9,57,758. I filed that acknowledgement on 18/11/2023.
There's a remaining 981 rupees. Have you deposited that?
That I'll have to verify, my lords.
Deposit the amount. Weeks time granted to deposit the balance amount. No representation. Release next week.
My lord, serial number 12, my lord.
Yes, Mr. Hegde, what is this?
Yes, my lord. Serial number 12, my lord. The cost title, my lord, before the tribunal, it's a New India Insurance Company, it has been shown. Correct, name is, my lord, New India Assurance Company Limited, my lord. So I have, in the note, I mentioned that also, my lord. And in the affidavit, my lord, actually this pertains to Kolar division. And my lord, the officer of the insurance company at Bangalore regional office has signed the affidavit regarding stay, my lord. So kindly, my lord, the office objection may kindly be overruled.
Objection raised by the registry is overruled. Heard learned counsel for the appellant. Issue notice to the respondents. Pending consideration of IA 1 for 24 for delay. IA number 2 for stay is taken up by imposing certain conditions. There shall be stay of operation execution of the judgment and award dated 21/10/23 in MVC 142 of 22. Subject to the condition, the appellant deposits 50% of the award amount before the jurisdictional tribunal within 4 weeks from today.
Yes,
On
ma'am.
such deposit, the same shall be kept in fixed deposit for a period of 6 months or otherwise ordered.
Obliged.
Number 13, BC Shivanegoda.
And for 2 weeks time may be granted. Will comply the office.
Time granted to comply.
Serial number 14, Jairaj GS.
I appear for the appellant. I take fresh steps in respect of respondent number 3.
Ah.
With respect to respondent numbers 1 and 2, both are dead. Their husband and wife. The necessary application are filed.
For R3, you want a week's time.
Please,
Week's time
for the
granted
third time. Ma'am.
to do the needful for issuance of notice to R3.
Yes.
The postal share of notice to R1A and R2A is received as unclaimed.
It is unclaimed. Therefore, my lord's notice is to be held served.
Hence, the notice to
Sufficient.
R1A and R2A is held to be sufficient. Registry to show their name in the cost list.
With respect to
About next, R2.
R2 is represented by an advocate.
No, R2A and R2B.
Yes, my lord.
To bring LRs of R2A and B.
Yes.
Only 2 LRs. 2 LRs.
Who was R2 has died, is it?
Yes, my lord. R1 and R2 both are dead. They are husband and wife. And their LRs are the children.
Notice is not gone to R. So 1B and 2B are represented.
Please, please.
What is that application? Heard learned counsel for the appellant. Notice to respondent number 1A, R1A and R2A, since served are held to be sufficient. Hence, these orders on IA number 1 of 19 and IA number 1 of 21. I've perused the affidavit next to these applications,
2 LRs.
seeking to bring on record R2A and 2B. And 1A also, is it?
Yes, my lords.
R1A, R2A and 2B.
R1A,
2B already is represented, Allah.
Please, my lord.
2B is already represented.
Yes, yes, yes.
So only 2A.
Yes, my lords.
2A and 2B are talking. 2A and 2B. I'm satisfied with the reasons assigned in the affidavit annexed to the applications. These two applications are allowed. The LRs of respondent 1 are permitted to be 1 and R2 are permitted to be brought on record as R1A,
R1A and B, R2A and B.
R1A also has to be brought
Yes,
up.
yes, R1 AB, R2 AB.
R2A and R2B.
Yes. Same with respect to R1 also.
R1B also.
Yes, ma'am.
R1A, R1A, R1B, R2A, R2B.
Please.
Learned counsel for the appellant to carry out the, is there any delay?
No, my lord, there is no delay.
Carry out the amendment, file the amended cost title by furnishing a copy of the same to the learned counsel for respondents.
I will carry out the amendment now. It's
Permitted.
Seal number 15. I appeal for the appellant, my lord. I have served a copy on to my learned friend. I may be permitted to take steps in regard of respondent number 8C and 15 by way of email, my lords. Who they are residing in US, and that is why the service is not completed.
Acceptance of acknowledgement in respect of R7,
E and R7F, my lordship,
which
That
cannot
is
be
the-
identified.
not been identified. The service may be deemed, my lordship.
How? When it is not identified, how it can be held? You are appearing for whom?
Lord, R16, man. I appear for respondent number 16.
So except 7E and F, all others are served.
Please, my lordship, respondent number 8C, we undertake to serve through email, my lord. They are residing in US.
R7. Acknowledgement. Acknowledgement. What do you say? Who's R7? Is he,
7, my lord.
who's R7?
He was defendant number 6 before the court below.
Who's the appellant?
The appellant is the plaintiff.
Plaintiff,
You are plaintiff.
please,
So R7 was defendant.
please.
Or suit for what?
Suit for partition and separate possession.
What's the name of R7?
I am Nirvane Gowda, my lord.
Huh?
I am Nirvane Gowda.
Madam, R7ERO.
E. Shabari Kadilal, my lord.
What about R7F?
Kaushik Kadilal. They are the sons of I am Shobha.
The same person, daughter is received.
Please.
You are related to R7.
No, my lord.
You are related.
Please, my lord.
Are you related to R7?
Please, we belong to a joint family, my lord. It was. a
What is
suit-
the relationship?
Please, I'm unaware of the relationship, my lord.
How to accept?
I seek
Where
a
are they
week's-
living? Shimoga.
Please, seek a week's time, my lord, to seek
Take
instruction.
steps again for this R7E
Please,
and F.
please,
And find out if they have a daughter.
please.
I don't know who was signed. The name also is not clear. And R8 you want to take by email.
Please, my lord.
The High Court rules have been amended. Any clue? Why? Any creator. Whether the High Court rules are amended,
Please,
take service of notice by email.
please, my lord, there is only a draft notification. I'm unaware if it has been amended. 2023, there was a draft notification.
You know the address of R8,
Please, my lord.
then you take by speed post.
Please, she's residing in USA, my lord.
Speed post will not go.
Please, my lord.
I'll permit you along with speed post email
Please,
that you take out.
please.
Week's time granted with regard to taking of steps to R7E and F, fresh steps. With regard to R8C, counsel for the appellant is permitted to take out notice through registered speed post and also by way of email as stated in the application. IA number
1 of 24. 1 of 20,
1 of 24.
please.
IA is allowed. You have any objection?
For the email, my lord.
All right.
Serial number
Take
six-
by speed post and DPA.
Please. 16. Mesh PH.
Week's time is granted to do the needful.
Serial number 17, hearing on IA.
For the appellant, company appeal. Is on liability ground. It is a company appeal, madam. IA 1 is 132 days delay. IA 2 is safer.
IA 1 of 20 is allowed. Delay of 132 days is condoned. What is the IA? IA 2 of 2020. It's filed for seeking stay of orders on IA 2. Stay of operation and execution of the impugned judgment and award dated 1/8/19 in MVC 1363 of 2017. Passed by Senior Civil Judge MACT Arsikere. Subject to the condition, the appellant deposits 50% of the award amount before the jurisdictional tribunal within 4 weeks from today.
Before this honorable court. There is DA, no DL.
Huh?
Before this honorable court.
Before this court.
Yes.
18, Shankar Gaud G.
For appellant, your climate appeal, my lord, for enhancement of compensation.
IA number 2 of 21 allowed 170 days delay condoned.
Serial number 18 ಅಲ್ಲಿ ಕಂಡೋನ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಡಿಲೇ ಅದು ಆನ್ 10/4/2024 ಲಾಸ್ಟ್ ವೀಕ್ ಮೈ ಲಾರ್ಡ್ ಓನ್ಲಿ ಒನ್ IA is not put up, that is IA for 1 of 2024 IA for dispensation of certified copy of producing judgment. Serial number 18.
But IA number 2 is allowed.
Allowed, my lord.
When?
On 10th April, my lord.
ತಿರ್ಗಾ ತೋರ್ಸಿದ್ದೀರಾ?
And IA
What about notice for R1?
ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನಾವು ತಗೊಂಡಿದ್ದೆ ಸ್ವಾಮಿ ಅದು ರಿಟರ್ನ್ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಂಡ್ ಅದರ್ 3 matters ಸರ್ವ್ಡ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಸರ್ವ್ಡ್
Who's represent?
ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್
Who's representing R1?
R1 is the owner of the vehicle.
Madam, who's the advocate representing R1?
No, my
No one
is
is
the part. Only party name is
So what is his status in other appeal? Is R1 in all cases?
R1 is
Yaru adu Ratnamana?
Ratnama, owner of the vehicle, my.
You still have to take notice.
He's placed an ex party in before I'll.
And you know
Yes.
what you should do, madam.
Yes.
If she is placed like what is, she is the owner.
Owner of the vehicle
He's
and
placed ex parte.
MACT has paid recovery order ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ MACT. Is a liab.
All the appeals are filed by you.
Yes, my lord.
You are claimant.
Climate up.
File a memo, whatever you want to file.
Next week, 22nd.
You have filed the certified copy in the other cases.
Swami. Certificate
one
copy I have filed in serial number 18.2, my lord. In other 3 matters I have filed.
So the dispensation has to be allowed.
Yes, my lord.
IE 1 of 21 in 18.3 is allowed. Certified copy is dispensed as the same is produced in MFA
serial-
2055 of 21. ಅದ್ರಲ್ಲಿ ಡಿಲೇ ಕಂಡೌನ್ ಆಗಿದೆಯೇನೋ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ.
18.3
18.3 ಅಲೋ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
IA number 1 of 21, 2 of 21 is allowed delay of 170 days is condoned. All right.
Monday,
18.2, a week's time granted to take steps for R1.
next
Number
week,
19.
Swami.
Pradeep B.
Nimsha. Furnishing others the week's time to do the needful. You have to pay the process fee, fresh
19.
process fee.
B. Pradeep.
I am for appellant, my lords.
Yes, for respondent.
Awaiting.
Deposited.
Please, my lord, we have deposited, my lord. Our
Kindly, Lordship, and kindly direct the trial court to release 50% amount.
challenge.
I filed application, IA is pending. By
My lordship, arising same out accident, my lordship, almost 6 cases is remaining pending, my lordship. Matter may be posted final hearing, my lord, we can dispose of this matter, my lordship.
my humble submission,
One owner has to, in 1 MVC, in learned MSCT has been fixed against the insurance, owner of the vehicle, my liability fixed against. Another remaining 4 cases, insurance company has liability fixed, my lord. Matter along with, call along with my matter may be posted final hearing, we can dispose of this matter, my lord.
my humble submission is, so in complaint, it is stated Manjunatha son of Girigamba. In charge sheet, they have stated Manjunatha son of Venkatrayappa, accused person. So, but in the trial before the tribunal, they have not discharged their liability. The insurance company has not discharged their liability with respect to the DL is concerned. But in the charge sheet, the person who holds DL is named as the driver. That has not been challenged by the insurance company. And apart from this, no evidence is adduced by the insurance company to show that he is not the driver. The charge sheeted person is not the driver. And there is nothing. No evidence is adduced. So just they are placing this argument before the appellate court, before your lordship. Kindly direct the tribunal to pay the 50% amount, my lord, in my case.
Insurance policy is in force.
Yes, yes, my lord, it is in force.
Pulse is
You are challenging what?
implication of driver, my lord.
DL.
Implication of
Driver,
wrong driver is mentioned.
please, my lord.
Have you filed objection to this application?
My lord, we have not filed objection, my lord.
File objection.
Please, my lord, I will file objection today's time,
First
my lord.
file this memo for dispensation.
19.1. Tippeswamy BC.
Dispensation ಯಾರ್ರೀ ಹಾಕಿರೋದು?
Claimant I have filed, my lord.
You are Tippeswamy?
No, my
No,
lord.
my lord, I am Nanjundas.
Tippeswamy is one more of claimant of
Another claim petition.
So there's a common judgment.
common judgment.
No, not common judgment. My petition is filed before MACT Shidlagatta. The other three.
You are only in serial number 19.
Yes,
19.
You are not in other matters.
no.
In
In
that case,
19, they have deposited 50% amount.
That's okay, sir. Who's R2 in the connected matter? 19.1.
19.1.
19.1, 2, 3, 4.
You are R1.
I am for R1.
R2 here.
R2 is,
Tippeswamy is for claimant.
please, my lord. Tippeswamy BC is a claimant, one more claimant.
All right. What about then R2 must be the owner?
Please, my lord.
Is he required?
Is required, my lord, because his liability challenging.
3582 ಅಲ್ಲಿ ತಿಪ್ಪಸ್ವಾಮಿ ಕೇಸಲ್ಲಿ ನೀವು ಕೌಂಟರ್ ಹಾಕಿದ್ದೀರೇನೋ ಅದರಲ್ಲಿ?
No, my lord, we have filed, insurance company also filed, my lordship, same
Which is that appeal?
bill number. Shantamma.
There is no representation on
5246 up to 2021, my lord.
7416.
on behalf of appellant in 19.1, MFA number purple. Avoid service of notice in 19.2. IE 1 of 23, IE in 19.3. IE 1 of 23 is allowed delay of 170 days in filing the appeal is condoned. 19.4 IA 1 of 23 is allowed delay of 203 days in filing the appeal is condoned. Who's R1 in that case? 19.4?
19.4 Ramchandra is GV Ramchandra is claimant, my lords.
Notice ಹೋಗಿಲ್ಲ ಅವ್ರಿಗೆ.
Notice they have not taken, my lords.
Huh?
Dispensation respond number 2 is they filed dispensation respond number 2.
ನಿಮ್ ಕೇಸಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಂಡಿದ್ದಾರೆ.
We have taken notice is awaiting service of notice.
That is not shown. Why? ಅದು ತೆಗಿಯರು. Delay ತೆಗೆದ.
6377.
18.4 cancel that order. Await service of notice. What happened? Delivered. Await service of notice to R1. Call this matter on 23rd.
Meanwhile, call for TCR, my lords.
File objections to his application
Please,
for
my lord.
withdrawal, sir. Secure TCR.
Till number 20. Yes, Nirmala.
And for the appellant in 54, 54 of 21, my lord. My lord, your lordship is directed to inquire about the driver, what has happened in the criminal case, my lord. In 2019 itself, my lord, he retired and he has been acquitted. It seems our security people are
ಕನ್ವಿಕ್ಷನ್ ಆಗಿದೆ, ಪ್ಲೀಡೆಡ್ ಗಿಲ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಏನು ಸಿಕ್ಕಿಲ್ಲ ಸರ್. ಅಲ್ಲ, ಅವ್ರು ಬರ್ದಿರೋದನ್ನ ನಮ್ಮ ಹತ್ರ ಏನು ಇಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರನೇ ಡ್ರೈವರ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿದ್ರೆ ನನಗೆ ಬಿಡುಗಡೆ ಆಗಿದೆ, ನನ್ನ ಹತ್ರ ಏನು ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ he retired in 2019, my lord. Only we cannot expect much support from him.
Partly erred, my lordship, and directed to secure the criminal case status.
Criminal case the number ಹೇಳಿದ್ರೆ ಸ್ವಾಮಿ, ನಾನು I'll try to secure the records, man.
Pleaded guilty ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್. Plead guilty ಮಾಡ್ತಾರೆ.
Plead guilty is not the this thing. No proceedings have been conducted. Trial ಆಗಿದೆ.
Fully. Argument ಆಯ್ತೇನಾ?
ಆಗಿದೆ.
ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಹೇಳಿ ಪಾಸ್
ಓವರ್.
ಬೇಡ ಸ್ವಾಮಿ, ಪಾಸ್ ಓವರ್ ಬೇಡ ಸ್ವಾಮಿ. I have some other matter in there. Kindly have it after vacation, sir.
ಅಲ್ಲ, my lordship, kindly have it on 24th.
Heard you already. Where is the question?
24 ಅಲ್ಲಿ ಇನ್ನೇನ್ ನೆಕ್ಸ್ಟ್ ವೆಕೇಶನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿ ಹೋಗುತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಆ ಕಡೆ ಈ ಕಡೆ ಒಂದು 20 ಅಲ್ಲ, ಇನ್ನು 10 days ಇದೆ ಅಷ್ಟೇ ವೆಕೇಶನ್. ವೆಕೇಶನ್
argue the matter. I have heard you.
I heard your lordship has heard it and directed me to take it.
Why I have to adjourn it at your asking for after vacation?
ರೀಚ್ ಆಗತ್ತೆ ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ವೆಕೇಶನ್ ಅದಕ್ಕೋಸ್ಕರ.
Matter of 21, so an injury case. Why was this asked record with regard to the criminal case?
Regarding my
Because, my lord, he has filed all concocted document, my lord. The bus number, what he stated in FIR, wound certificate, everything is a different number. And only in charge sheet, my lord, suddenly they brought the other vehicle. That is what even the IME has been conducted after a period of 6 months. That is what we are telling, completely a concocted documents. And even in cross-examination also, my lord, he has agreed that his FIR and a wound certificate, whatever he stated before the doctor, is also correct.
CC number. Madam, you write down the CC number 1782
Yes, madam.
of 19.
I'll get the records, madam. ನೋಡೋಣ ಸಮಯ, ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ. ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಅಂದ್ರೆ ಏನು ಸಿಗೋದೇ ಇಲ್ಲ ಸಮಯ ಅವಾಗ. ಯಾಕಂದ್ರೆ ಇವರು
ಅವ್ರು ತಗೊಂಡಿದ್ದಾರಮ್ಮ,
ಅದ ತಗೊಂಡಾದ್ಮೇಲೆ ಈಗ ಅಲ್ಲಿ ಏನು ಸಿಗೋದೇ ಇಲ್ಲ ಅವಾಗ.
Released after summer vacation at request of counsel for the corporation.
Till number 21. Deepak BR. Deepak BR.
Last time something with the order sheet. ಯಾರು ಇದು ಫೈಲ್ ಮಾಡಿರೋದು? ಕೊಡಿ, ಇದು ಕೊಡಿ. ಕ್ಲೇಮ್ ಅಪೀಲ್.
Serial number 21, Deepak BR.
This appeal came to be dismissed on 15/3/23. Pursuant to which learned counsel for the appellant has filed applications to recall the order along with applications for condoning the recall the order. There is no representation on behalf of appellant, even on the last date of hearing. So also today, it appears that the appellant is not interested in proceeding further in this case. Hence, IA number 1, 2 are dismissed. Or again, non-prosecution.
Number 22. Santrajki.
Yes.
Case of death.
Delay of 1392 days.
Yes. This court, the division bench of this court, delay of 3,318 days has been condoned. In
Mr.
MF,
Which is condoned?
3,318 days delay has been condoned. And apex court,
The case of death, is it?
case of death,
So accident happened in 14.
in the present
Yes, sir. Please argue the case
accident is of the accident
on
is
delay, on delay.
on delay. This,
You're having serious objection.
Yes, my lord, I filed my objection.
All right, on delay, please argue.
yes. And apex court also, this court has dismissed the appeal on the ground of delay. I approached the apex court, and apex court has directed this court condoning the delay. It has to be considered on merits, not on question of delay.
What are the facts in your case with regard to delay?
Question of, this is a case of death. The reasons assigned by the appellant for condonation of delay. And in fact, the apex court, in case of Sheshnath Singh and another versus Baidabati Sheropalli Cooperative Bank Limited and another, in civil appeal number 9198 of 2019, reported in 2021 AR 2637, it has been held that Section 5 of the Limitation Act is only a general
Sir, Mr. Shantaraj,
Yes.
now on delay only, what is the ground for delay? First you come to that, then we'll come to the authorities. What is the reason for delay in your, this one, that you please submit?
I'm submitting the delay will not come in the way. It has to be decided on merits. My argument is delay will not come in the way in the Motor Vehicles Act. There was no limitation prescribed in the Motor Vehicles Act. It is continuation of the claim petition. Therefore, question of delay does not arise. We have to look into the merit of the case.
And why you filed application for condoning delay?
Yes, for that answer, Apex Court has answered. Section 5 of the Limitation Act is a formal one.
What is the reason for delay in your case?
My case, in my case, I narrated the delay for in filing the appeal is due to, you will not kindly see me. Para 2 of my affidavit. I submit my son met with a motor accident on 12/5/2014 and he died. We being the dependent filed a claim petition before MACT SIRA claiming compensation of rupees 12 lakhs in MEC so and so, and MACT has passed judgment and award dated 4/11/2016 awarding a compensation of rupees 8,70,000 and directed the insurance company to deposit the award amount. And the insurance company has not deposited the award amount in time, since we are mainly depending upon the income of the deceased, and it was very difficult for us to maintain the family. And in the meanwhile, COVID-19 has started and the limitation period has been extended from time to time. And we approached the Bangalore advocate in the month of November 2022, and appeal has been filed today. And there is some delay in filing the bona fide reason stated above, and it is not intentional and deliberate one, and therefore it is just and expedient to condone the delay. Since we have got very good case on merits and we are likely to succeed in the above appeal, and meritorious case should not be thrown out at the threshold.
Yes.
Lord, I have filed my objection. Your Lordship, may kindly see the case was disposed of on 14/11/2016, 4/11/2016. Your Lordship, may kindly see the copy application for certified copies was made on 8/2/2008/21. That is after a lapse of 5 years. And the copy was ready on 23/2/2021. The copy was not obtained immediately. The copies were obtained on 9/7/21. There is also delay. Now, Lord, the reason what has been narrated in the affidavit is not sufficient to condone the delay. Your Lordship, may kindly see para number 2, at page number 2, 5th line. There is some delay. Lord, the delay is of around 7 years. For 7 years, they say that only some delay. The reason assigned in the affidavit cannot be considered to condone the delay at all. No, my Lord, I'll be relying on the ruling of the Honorable Supreme Court, which was delivered on 8th of April. I'll take your Lordship to para number, page number 15. No, this is under the Land Acquisition Act. The Lordship, at para number 12, it is the settled legal proposition that the law of limitation may harshly affect a particular party, but it has to be applied with all rigor when the statute prescribes. The court has no power to extend the time of limitation of equitable ground. A result following from the statutory provision is never an evil. A court has no power to ignore the provisions to relieve what is a court has no power to ignore that provision to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice to enforce it, giving it a full effect to the same. The legal maxim dura lex sed lex, which means the law is hard, but the law is a law, that the law is law. But the stands are attracted in such a situation. It has constantly been held that the inconvenience is not a decisive factor to consider while interpreting a statute. The law on the issue can be summarized to the effect that where the case has been presented in the court beyond limitation, the applicant has to explain the court what was the sufficient cause. Now, my lord, in this case, the sufficient cause has not been explained, which means an adequate and enough reason which prevented him to approach the court within the limitation. In the case, a party found to be negligent or want of bona fide or on his part, in the facts and circumstances of the case are found to have not acted diligently or remained inactive, there cannot be justified ground to condone the delay. No court would be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the parameters laid down by the court in regard to the condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on time, condoning the delay without any justification, putting any condition whatsoever amounts to passing of an order in violation to the statutory provisions, and it transport amounts to showing utter disregard to the legislature. On a harmonious consideration of the provisions law, as aforesaid, and the said law laid down by the court, it is evident that law of limitation is based upon the public policy that there should be an end to litigation by forfeiting the right to remedy rather than right itself. A right or remedy has not been exercised, availed for so and so long time, cause exists for so and so period. The provisions of the Limitation Act have to be construed differently, such as Section 3 Section 3 has to be construed in strict sense, whereas Section 5 has to be construed liberally. In order to advance substantial justice, though liberal approach, justice-oriented approach or a cause of substantial justice may kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. Courts are empowered to exercise the direction to condone the delay if sufficient cause has been explained, but that exercise of power, the power is discretionary in the nature and may not exercised even if sufficient cause is established for various factors, such as where there is inordinate delay, negligence, and want of due diligence. Merely some persons obtained the relief in a similar manner. It does not mean that others are also entitled to the same benefit if the court is not satisfied with the cause shown for the delay in filing the appeal. Merits of the case are not required to be considered in condoning the delay. My lord, this would be relevant to my learned friend's submission. The delay condonation application has to be decided on the parameters laid down for condoning the delay, and condoning the delay for the reason that the conditions have been imposed tantamounts to disregarding the statutory provision. In the light of the above legal position, that now we have to test whether inordinate delay in filing the proposed appeal ought to be condoned or not in this case. The submission of the learned counsel for the petitioners is that in somewhat similar situation, delay in filing an appeal for the enhancement of compensation had been condoned by this court in so and so case. In this case, delay in filing the appeal was condoned in order to, in the other appeals, compensation awarded by the rate at 200 per square feet was upheld, and proposed appellants were so and so. The other decision relied upon in this regard so and so. In this case also the matter was regarding the determination of the compensation so and so. The aforesaid decision, I'm reading para number 30. The aforesaid decision would not cut any ice as imposition of conditions are not warranted when the sufficient cause has not been shown for condoning the delay. Secondly, delay is not liable to be condoned merely because some persons have been granted relief on other case. Condonation of delay in such circumstances is a violation of violation of legislature intent or the express provisions of the statute. Condoning the delay merely for the reason that the claimants have been deprived of the interest for the delay without holding that they had made out a case for condoning the delay is not a correct approach, particularly when both the above decisions have been rendered in ignorance of earlier pronouncement of the case in Basoraj. Learned counsel for the petitioners next submitted that on the basis of the additional documents that in connection with the land acquisition in some other special leave petitions, delay was condoned, taking the lenient view, and the compensation have enhanced with the rider that the claimant shall not be entitled for the statutory benefits for a period of the delay in approaching this court or the High Court. The said orders do not clearly spell out the facts and the reasons explaining the delay in filing the appeal. But the fact remains that the delay was condoned by taking too liberal approach and putting conditions which have not been approved by this court itself. In the absence of such facts, getting the delay condoned in a referred cases vis-a-vis the facts of this case cannot be said to be facts of sorts. Lord, according to this, the delay has to be condoned only if there is a sufficient cause has been. My lord, the affidavit is bold so far as the condonation of delay is concerned, para 2, and more so, it is only said that there is some delay. My lord, as I submitted earlier, the certified copies were obtained after 5 years of the judgment. So this shows they were not diligent and they were negligent. So I request our to kindly dismiss the appeal along with the condemnation.
Yes, you want,
Which he has cited, it is under Land Acquisition Act. And in that case also, it has been referred section 3 and 5 of the Limitation Act.
already, you want to file better affidavit?
I can file better affidavit. So far as this judgment is concerned, in fact, it support my case. Section 5 and section 3 has been deferred.
I will deal with that.
Yes,
You
yes,
want to
ma'am. I will file better.
learn counsel for the appellant
I've also gone through that judgment.
seeks time to file a better affidavit. Release this matter after 2 weeks.
My lord, I appeal the appellant, my lord. So owner's appeal. My lord, IA 1 of 23, there is a delay of 20 days. A notice may be ordered to the respondent number 1, my lord, on the delay.
You are owner.
Owner's appeal. My lord. And Pradeep may be directed to take notice, my lord, if Tokyo, my lord, our second respondent.
First time, Allah.
First time.
Notice has to go.
Yes, ma'am. There's a delay of 20 days in filing. the
Heard.
appeal.
Counsel for the appellant issue notice to respondents. Pending consideration of IA number 1 of 23. IA number 2. For stay is taken up by imposing certain conditions. The issue notice ಆಗಿದ್ದೆಲ್ಲ ಅದರಲ್ಲಿ on main and IA. There shall be stay of operation execution of the dated 25 March 2023 in MVC 1916 of 19. The file of small causes judge MACT Bengaluru. Subject to the condition, the appellant deposits 50% of the award amount before the jurisdictional tribunal within 4 weeks from today.
Before this court, my lord.
Right?
Where I had to deposit, my lord?
Before tribunal.
Tribunal, how much?
Insurance ilva nimudre.
Insurance ಇದೆ, but their contention was he was a gratuitous passenger in a goods vehicle. So the liability has been passed on to the owner. So against insurance company, it is got dismissed, madam.
Deposit before the tribunal.
Yes, madam.
In 4 weeks from today before the tribunal.
I have deposit statutory deposit fee for 25,000.
Apart from that, you deposit 50%.
Yes.
On such deposit, the amount shall be kept in fixed deposit for a period of 6 months or otherwise ordered.
IA 3, my lord, additional documents.
That will be considered after notice.
The respondent filed an application for release of the deposited amount, case of death, and quantum has been challenged. There is no liability question.
ಬಂದ್ರೆ final dispose ಮಾಡ್ಬೋದು.
Next week or.
In final disposal ತನಕ ಅವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು?
A quantum has been challenged, a death case, no?
We filed objection.
No, man.
You're questioning only quantum.
Quantum only.
You're deposited 50%.
Yes, please.
I'll allow the IA. Heard learned counsel for the respondent. Number 1 and 2. The claimants before the tribunal was filed this application for withdrawal of the amount deposited by the appellant insurance company. Being satisfied with the reasons assigned and cost shown on the requirement of the amount, I deem it appropriate to allow the application. How much have you deposited?
12 lakhs, my lord, 10,940, 50%.
The amount in deposit is ordered to be released and dispersed in favor of the respondents 1 and 2 bar claimants in accordance to the proportionate share as ordered by the tribunal. The case of death, is it?
Please. My lord.
Full stop. Your deposit before the tribunal?
Tribunal, my lord.
The tribunal shall disperse the amount as per the terms and conditions of the award upon proper identification. This matter, you notice.
My lord, I'm appearing for appellants. You have filed the 3 appeals. Only one file is coming today to the court. So another 2 is not listed today. Sir. So kindly requested to.
What is the number?
1 week. Sir.
What is
That
the number?
matter, RSA number 996/2023 and 998/2020 is not stated.
RSA? Number ಹೇಳ್ರಿ.
RSA 996 of 2023.
996.
And 998 of 2023.
996 and 998.
Yes.
Of 23.
Yes.
The 2 and 3 6.
Therefore requested to next week.
Dismissed.
Yeah, next week, Swami.
Huh? Nine nine six and 998 has been delinked. ತಿರ್ಗಾ ಲಿಂಕ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಲಿಂಕ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
ಯಾಕೆ?
ಆಲ್ರೆಡಿ ಲಿಂಕ್ ಇದೆ, 3 ಅಪೀಲ್ ಲಿಂಕ್ ಆಗಿದೆ. ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
ಏನ್ ಲಿಂಕ್ ಇದೆ?
FTP ಆಲ್ರೆಡಿ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. FTP ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ.
ಇದಕ್ಕೆ ಏನ್ ಲಿಂಕ್ ಇದೆ ಅದ್ ಹೇಳ್ಬೇಕಲ್ರಿ ಲಿಂಕ್ ಮಾಡಕ್ಕೆ.
ಲಿಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ, ಇವಾಗ ಹೇಳ್ಬೇಕು ನೀವು.
3 appeals were filed against 3 appeals, 1 common judgment is given. Based on that, they had filed only 1 appeal. Then when opposed, challenging 3 RA, they have filed 1 RSA. So when it was opposed, then they came and filed in 2023. The other 2 appeals, though the first appeal is of 2016.
All right, but that is also arising out of the same.
Yes.
Why it was
partition suit.
And why it was delinked?
The matter was referred to mediation, so they must have been delinked.
You are having that appeal RSA 996 and 998 with you?
Yes, me.
ಇದೆಯಾ?
ಇಲ್ಲ sir.
Appeal code. What is the original suit number in that case? What is the original suit number in that case?
Original suit, don't know sir. Senior counsel is saying.
ನಿಮ್ಮ ಹತ್ರ ಈ copy, have you been served in that, madam? You are served in those 2 cases?
Yes, sir.
2023 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು.
Yes, sir.
You are served?
Yes, sir.
So it is arising of OS number 102.
Yes, sir.
And RA number?
RA numbers, 3 different numbers.
24 and 31.
Yes, sir.
Then it is linked and connected.
Yes, sir.
It should not have been delinked.
Delinked.
ಏನು ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ? Huh? ಹೋಗ್ಲಿ. R2 is dead, is it?
Yes, sir.
Record. Issue notice on I number 1, 2, 3 of 2023 and I number 1, 2 of 2019, I number 1, 2 of 2016. Full stop. Learned counsel for the appellant submits that RSA 996 and 998 of 2023 are filed by whom? That is filed by whom? Plaintiff or defendant? Who are you?
Defendant.
He is
And
defendant.
for plaintiff.
He is defendant.
Yes, he is.
So those two appeals are filed by which defendant?
Three, plaintiff has filed one appeal and the other two appeals are filed by defendants.
You also filed one appeal.
Yes, sir.
Which is that appeal number? That is other than these two numbers.
No, RA 31 of 30.
ಇಲ್ಲಮ್ಮ ಆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ನೀವು ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ. ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅವ್ರು ಹಾಕಿರೋದು. RA ನಾನು ಹಾಕಿರೋದು.
ಸೆಕೆಂಡ್
ಸೂಟ್
ಅಪೀಲ್
ಅಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದ್ದು ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿ ಪ್ಲೇಂಟಿಫ್ ಒಂದು ಅಪೀಲ್ RA ಹಾಕಿದ್ದಾರೆ, ಡಿಫೆಂಡೆಂಟ್ಸ್ ಎರಡು ಹಾಕಿದ್ದಾರೆ. ಕಾಮನ್ ಜಜ್ಮೆಂಟ್ ಆಗಿದೆ. ಆ ಮೂರು ಅಪೀಲ್ ಮೇಲೇನು ಕಾಮನ್ ಜಜ್ಮೆಂಟ್ ಆಗಿರೋದ್ರಿಂದ ಅವ್ರು RSA ಬಂದಿದ್ದಾರೆ. ಚಾಲೆಂಜಿಂಗ್ ಆಲ್ ದಿ 3 ಆರ್ಡರ್ಸ್. ಬಟ್ ಒಂದೇ RSA ಹಾಕಿದ್ದಾರೆ 2016 ಅಲ್ಲಿ. ಆಮೇಲೆ ಲೇಟರ್ ಆನ್ 2023 ಅಲ್ಲಿ ಎರಡು ಅಪೀಲ್ ಆಗಿದೆ.
ಏನ್ ಬರ್ದ್ರಿ? Defendants challenging the very same common order passed in this first appeal arising out of the original suit OS number 102 of 2005. Though this court has passed an order on 11/9/23 ordering delinking of said RSA mentioned herein above. In view of the submissions made by learned counsel for the appellant and learned counsel for the respondent, it appears that the above said two second appeals are also related to this very same case arising out of the suit and the regular appeals. Hence, post along with RSA 996 and 998 of 2023. We'll call it together. You have any objection? You have any objection in calling those matters together?
No, no.
For appellant in this matter also, 202 days delay in filing the appeal. Kindly issue the notice to.
Issue notice to respondents.
To the respondent claimant, one submission, Lords. Lord, this is a matter where workman under the Workman Compensation Act, claim has been made, claim has been allowed, against which insurance company has preferred an appeal. But on the last occasion, an issue had arisen before this court, whether they are covered under the insurance or not. Lord, our submission is that though he is a cleaner come loader, He is covered under the Act policy. Statutorily, there is a coverage. But I require some judgments to be cited before this court, my lords. Otherwise, my lords, subject to what your lordship says, matter may be admitted, posted for hearing also, I have no problem.
All right, we'll admit it. You have deposited the amount?
Deposit.
Your insurance company,
Insurance.
admit post for hearing.
Please.
Kindly grant weeks the time, my lord. I will serve the copies, my lord. Appeal.
Learned counsel for the appellant seeks time. Released after 2 weeks.
Much.
Patel D. Karegowda.
My lord, appearing as an appellant, my lord, I pray for a short accommodation, my lord, since my leg I'm recovering.
What, Mr. Shreyas?
My lords, am I audible, my lords?
You are audible, but you are not visible. You are only, I can see only your band.
Sorry, my lords, there could be some technical error, my lords.
Now I can see your handsome face.
Sorry, my lords. My lords, I pray for a short accommodation since my leg am hurt, my lords. So kindly requesting for an adjournment, my lords.
All right. Where is Mr. Mahesh? At request of learned counsel for the appellant, Shri Shreyas. Release this matter after 2 weeks.
Please. Also, my lords, if I'm permitted, serial number 41 and 42, my lords.
Yes.
Can I request my lords to post it next week, my lords? A date might be given. I'll argue the matter, my lords.
After 2 weeks, I'll post this also. You get well.
My lords, I'm almost getting well. I'm ready to argue, but I'll come before my lords to argue, my lords.
All right, you're welcome, but Mr. Rao, Seshagiri Rao is also here. He wants it after vacation. So you come, we'll post it after 2 weeks.
Please, my lords.
See, 41.
41 and 42, my lords.
41 and 42 at request of learned counsel for the appellant, released after 2 weeks.
Much obliged, my lords.
For respondent number 1, my lords, case of injury, my lord. Call for TCR, required TCR, my lords.
Notice complete agideyalla? Secure TCR.
For the RTO, my lord.
You're ready.
We have not received copies.
Copy sikilla. No representation for appellant. Copies to be served to respondent number 2, released after 2 weeks.
Much of
Ravi Kumar N.R. No representation on either side, release. Either side better. Appellant.
My lord, one submission, my lord.
Released. Yes. Yes, Vijay Kumar.
My lord, I am for the respondent, my lord.
ಇಲ್ಲ ಅಪೆಲೆಂಟ್ ಇಲ್ಲ.
ಅಪೆಲೆಂಟ್ ಏನೋ ಪೋರ್ಟಲ್ ನಂಬರ್ 15 ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
ಬರ್ತಾರಾ?
ಬರ್ಬೋದು, ಒಂದು ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
ಆಲ್ ರೈಟ್, ಪಾಸ್ ಓವರ್. ಆನಂದ.
Appearing for appellant, my lord. Case of injury, my lord.
So Mahesh. Pass over.
Almost 3 or 4 times again.
Pass over. You argue, I will hear you.
Yes, ready, my lord. Pass over.
For appellant, my lord. My lord, the case of injury, my lord.
My lord, Palakshya prays for the short accommodation.
ಇದರಲ್ರಿ ಬೆಳಗ್ಗೆ.
My lord, this matter was listed so many times, sir. He's not complied the.
Yes, come today.
He's in the veranda. He was in the veranda.
We bring him from veranda into the court. Veranda in the court ಕರ್ಕೊಂಡ್ ಬನ್ರಿ ಒಳಗೆ.
Your answer kindly pass over. I will bring him.
ಇವಾಗ ಇದೆಯಲ್ಲ ಇನ್ನು 1 hour.
Kindly pass over.
Pass over. See, afternoon there is no sitting.
Saturday to Friday, my lord.
ಯಾವಾಗ ಅವ್ರ ಮನೇಲಿ ಮದ್ವೆ ಯಾವಾಗ?
26th. Next week.
I'll have it after vacation. Let him celebrate his.
Okay, my lord. Date may be fixed.
Date ಮಾಡಕ್ಕಾಗಲ್ಲ. At request of learned counsel for the corporation, Allah?
No, corporation.
Release it after 2 weeks. 2 weeks.
Date may be picked.
Date
After
kodak
vacation,
baralla.
date may be.
After vacation, date kodak baralla nanage. Please understand, the roster will change. If I am there, I can give the date. Mostly I will not be here for this roster, next roster.
For respond number 2, Mara. Required TCR, Mara. Case of injury.
ಅವ್ರಿಗೆ ಹೇಳಿದಾರೆ ಮುಂಚೆನೆ.
I have informed, Mara.
ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ ಅವ್ರು 100% disability ತಗೋಬೇಕು ಅಂತಂದ್ರು ಅದಕ್ಕೆ. Call for
Secure TCR. Nagaraj, Mr. Nagaraj. Renuka. So yes, Nagaraj. No representation on either side. Release next week. Ish. Ready?
Ready.
ಪಾಸ್ ಓವರ್ ಮಾಡುವೇನು?
ಹಾ, ಪಾಸ್.
ಬಂದಿದ್ದಾರ ಅವರು? ಕೃಷ್ಣಸ್ವಾಮಿ
ಇದಾರೆ ಸರ್.
ಹಾ?
ಇದಾರೆ, ಪ್ರೆಸೆಂಟ್ ಇದಾರೆ.
ಬಂದಿದ್ದಾರಾ?
Yes, ma'am.
ಪಾಸ್ ಓವರ್. You have to come before 1:30.
ಪಾಸ್ ಓವರ್ ಮೇಲೆ ಅಡ್ಡಿಲ್ಲ. ಸೋಮವಾರ ಹಾಕಿದ್ರೆ ಇದು ವಿಡಿಯೋದಲ್ಲಿ ಇರ್ತೀನಿ ಅಂತ ಹೇಳಿ ಸೋಮವಾರ ಹಾಕಿದ್ರೆ.
At request of respondent released on Monday.
ಮಚ್ಚು.
22nd. Released next week. Secure TCR.
First respondent, the driver, file a memo for dispensation. Second respondent, KSRTC Malad, K. Nagaraj is directed to take notice.
Notice to R1 dispensed. Issue notice to R2. Third, learned counsel for the appellant. Issue notice to respondents on main and IA. Orders on IA 1 of 24. That shall be stay. So and so order dated 29/9/23 in MVC 318 of 18, passed by second additional senior civil judge MACT Chikmagaluru. Subject to the condition, the appellant deposits 50% of the award amount before the jurisdictional tribunal within 4 weeks from today. On such deposit, the same shall be kept in a fixed deposit in a nationalized bank for a period of 6 months or otherwise ordered. Until otherwise ordered. Ready? Third, issue notice to respondents. Orders on IA1. Stay. Order dated 26/12/23 MVC 175 of 22, passed by second additional district and sessions judge, additional MACT Kolar. Subject to the condition, the appellant deposits 50% of the award amount before the tribunal within 4 weeks from today. On such deposit, same shall be kept in FD for a period of 6 months until otherwise ordered.
Challenge the
Same order, issue notice and same order.
File a memo for dispensation on second respondent.
Yarge?
Second respondent.
Notice to R2 dispensed. Issue notice to R1, na?
Yes, my lord.
Stay of order dated 6/12/23 in MVC 250 of 21, passed by fifth additional district and sessions judge, additional MACT Shimoga, sitting at Sagar. Subject to the condition, the appellant deposits 50% of the award amount before the tribunal within 4 weeks from today. Same shall be kept in FD 6 months until otherwise ordered.
out with the objections, Your Lordship.
ಮಾಡಿದ್ದೀರಮ್ಮ?
Yes, Your Lordship, I have done it.
Heard. Learned counsel submits that she has complied with the objections in the open court today. Registry to verify. The meanwhile, issue notice to respondents. Orders on IA, number 1 of 24. Stay of the order dated 22/12/23 in MVC 674 of 22, passed by Additional Court of Small Causes, MACT Mysuru. Subject to the condition, the appellant deposits 50% of the award amount before the
Tribunal itself. Your Lordship.
tribunal within 4 weeks from today. Same shall be kept in FD 6 months until otherwise ordered. Rajkumar, Ravi Kumar, sorry, Ravi Kumar. You are ready, Ravi Kumar? Ready na?
ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಮಂಡೇ. ಅವರು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಕಾಪಿನ ರೆಡಿ ಇದೆ. ವಿಜಯ್ ಕುಮಾರ್ ರೆಡಿ ಮಾಡ್ಕೊ ಬಂದಿದ್ದೀನಿ. ಅವ್ರಿಗೆ ನನಗೆ ಕಾಪಿ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರು. ಅದಕ್ಕೆ
Vijay Kumar.
My lord, I am for the respondent, my lord.
Ravi Kumar is here. He wants to give you the copy.
Yes, I'll give to the court officer. I'll collect it, my lord.
All right.
In fact, my son is there. I told him I will send them a number also to give it to him.
Where is your son?
Yes, he's in the High Court only. I given his number also. I send it by
Yes, I have the
WhatsApp.
pleasure of meeting your son.
I'll say, but he is not enrolled, my lord. He's still a student. He's still a student.
ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ ಮಂಡೇ ಮೇಲೆ.
All right. Learned counsel furnishes copy of the appeal memo to the court.
And judgment copy also furnished.
Release this matter on Monday, 22nd.
Please, madam.
22.
Much obliged.
Anand. O Mahesh idara? Want to wait some more time? Sweet. May come. Satish and Krishna Swami.
48.
38. Elri Krishna Swami.
Only loss of dependency justice.
If you want to wait, you can wait. You still have half an hour.
8 months. Pass.
If he comes, I will take up. No other matter is there.
Pass.
Maybe have the Anup,
Serial number 45.
40,
Fresh matter 45.
45. Nobody was present.
I'm sorry.
Stay granted.
Before this court, no?
The tribunal,
Tribunal.
50%. ಇವತ್ತೇನು ಬರಂಗಿಲ್ಲ ಮೇಡಮ್ ಅಂತ ಕಾಣಿಸುತ್ತೆ.
ಅಲ್ಲ 48. Sorry, Ashok and Patel.
ಏನ್ರಿ ಸತೀಶ್?
Ready?
ಅವ್ರು ಬರಂಗಿಲ್ಲಲ್ಲ ಇವತ್ತು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಡ್ಮಿಷನ್ಗೆ ಹೇಳ್ರಿಲ್ಲ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರ್ತಾರ ಅವ್ರು ರೇಣುಕಾ ಮೇಡಮ್.
Date ಕೊಡಿ. Saturday. Serial number after tomorrow.
19.
Pass out. Sorry, my lord. Serial number 46 ಅಲ್ಲಿ ಅಶೋಕ್ ಎನ್ ಪಾಟೀಲ್ ಅಲ್ಲಿ ಮೆಮೊ ಕೊಡದ ಡಿಸ್ಪೆನ್ಸೇಷನ್
46
ಹೌದು ಸ್ಟೇ ಆಗಿದೆ.
ಯಾರಿಗೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್?
Fourth respondent.
Respondent number 4. Notice to R4 dispensed. Memo accepted. Serial number 46. Stay granted. Pass over. So you have no opponent?
I have no opponent.
Injury case?
What?
Injury case.
ಹೌದು.
What are your questions?
Kindly pass on ಸ್ವಲ್ಪ brush up ಮಾಡಿ. Kindly pass on.
Okay.
ಸ್ವಲ್ಪ ಓದ್ಬೇಕು.
ನೀವು ಒಪೋನೆಂಟ್ ಇಲ್ಲ ಓದ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಾ? ನಾವು ಕೇಳೋದೇನು?
I'll assist the court minutes. Kindly pass on.
ನೀವು ಅಸಿಸ್ಟಿಂಗ್ ಅಲ್ರಿ ಇವಾಗ. You are against the claimant's order.
Please.
To set aside or reduce it.
Reduce.
Though it is served, nobody is representing claimant. We'll have it next week.
Please,
By then, if they come or some assistant could be taken from Legal Service Authority.
please, my lord.
Whether does it call for reduction or not, we'll see.
Please, my lord.
But release this matter next week.
My lords, direction may be given to them, my lords, for appearance.
Next week or Barlilla andre ಬರ್ಕೊಡು.
Or Baradilla. He had purchased the vehicle. He was a 17-year-old boy. He had purchased the vehicle and he was using his own vehicle. Hence, there will be no liability on the company.
He had purchased the vehicle.
He had purchased the vehicle,
They are the offending vehicle,
offending vehicle.
respondent.
How?
So it was not transferred in his name.
No.
So who's implicated?
My lords,
Who's implicated?
the previous owner.
Which respondent is that?
My lords, the respondent, number 2.
But that vehicle is insured with you.
ಹೌದು. ಅಲ್ಲ, respondent number 3, my lords, I'm sorry.
But insurance runs with the vehicle.
Huh?
You are the insurer.
I'm the insurer.
Whether A or B, it runs with the vehicle.
Agreed, my lords, but owner becomes the claimant in this case.
Owner becomes the,
Claimant. Owner is the claimant.
is a driver, rider, come owner, is it?
That is our case.
All right, we'll see. Next week, we'll open the file. By then, you also go through.
Please.
Yes. Ready? Yes, Mr. Vijay Kumar,
Please, my lord.
serial number 50.
Yes, my lord, I am ready, my lord.
ಹೇಳಿ.
My lord, this appeal is by the BMTC, my lord, challenging negligence and quantum of compensation awarded by the tribunal. My lord, the accident has taken place on 30/9/2019 at about 2:10 p.m. My lord, when the BMTC bus was going from Hebbal to Silk Board, when it was near Agra bus stop in the ring road. My lord, after stopping in the bus stop, then the bus was entering the main road. At that time, the my lord injured actually is the rider of the motorcycle. He came from right side and dashed against the right side middle portion of the bus. Right side middle portion of the bus. Even as per IMV report, my lord, it is only the right side middle portion of the bus is scratched. And the entire front portion of the motorcycle is damaged.
Yes.
And my lord, in the as per exhibit P7, my lord,
Pillion rider.
as per exhibit P7, the discharge summary of the Greenview Medical Hospital, it is shows that he himself was riding and met with an accident. But subsequently, my lord, in order to claim compensation, he claims that he is the pillion rider. My lord, one Mr. He has falsely implicated the rider as a rider, but rider has not sustained any injury.
Yes.
That means he himself was riding the motorcycle without a helmet, without a driving license. In order to claim compensation, my lord, he has falsely created the story of he being the pillion rider and the bus came and dashed against him. IMV report clearly shows that bus never dashed against the rider of the motorcycle or the motorcycle. My lord, police as usual, my lord, in collusion with the claimant, my lord, have falsely implicated the BMTC bus, though it is not negligent and responsible for the accident. My lord, the tribunal, my lord, without believing this, merely on the premise that the police have filed a false criminal case against the driver of the bus. My lord, in spite of the driver, my lord, RW1, Mahantappa, who examined as PW1, and he has clearly stated that as how the accident has taken place, and he was slowly moving from bus stop, and the rider came from right side and dashed against the right side middle portion of the bus. My lord, tribunal, without considering any of these aspects, merely because it is a heavy bus, government bus, and merely the police have filed a false criminal case against the driver of the bus, but it simply holds that the driver of the bus himself is totally negligent and responsible for the accident. But it is becoming very common in the present day of this thing. But your lordship knows very well how the riders of a motorcycle are riding the vehicle. But day before yesterday, my lord, 3 persons riding the scooter and wheeling and they went and went and fallen into the ditch, which was opened for BWSSB for maintenance and construction. Even after dashing the barricade, Malad, in the paper it comes, the BWSSB has opened the will, dig the road, not taken any care, that thing, this thing. Malad, is it possible everywhere, Malad, to keep a person, whoever comes, you stop and go slowly? After hitting 2 barricades, he went and fallen into the ditch. And it is published that as though the BWSSB is dig the hole, this thing, only for his fall. But every day thousands of vehicles are moving. It is not all of a sudden they have dig the BWSSB has dig the ditch hole or this thing by 10 by 20 feet this thing. ಎಲ್ಲ ಗಾಡಿಗಳು ಹೋಗಿದ್ದಾವೆ, ಯಾರು ಬಂದ್ ಬಿಡ್ಲ. ಈ ಹುಡುಗರು 3 ಜನ ವೀಲಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಈವ್ನಿಂಗ್ 8:30, 9 o'clock ಅಲ್ಲಿ ಹೆಲ್ಮೆಟ್ ಇಲ್ಲ, ಏನು ಇಲ್ಲ, ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಆ ಗಾಡಿಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಕೂಡ ಇಲ್ಲ, ಹೋಗ್ ಬಿದ್ರೆ ಪಾಪ BWSS ಮೇಲೆ unnecessary police case has been filed. This is how the happening, my lord. This has to be seriously viewed by the honorable court. Your lordship is rightly appreciating some of the incidents, my lord. I really grateful to this honorable court. Like that, my lord, the polices are, my lord, they should find out the real truth and then only they take the complaint from anybody. As usual, my lord, whenever 2 vehicles are involved, whenever the vehicle which met with the accident is no driving license, no license, then my lord, they falsely implicate other vehicle, though they are not negligent, though they are not at all caused the accident and not responsible for the accident. Like this also, one of this case, my lord, the bus is just moving from Agra bus stand and just entering the road, maximum, my lord, 10 to 15 kilometer speed. And my lord, he came and dashed against the right side body of the bus, and police filed case against the driver, saying rash and negligent. And tribunal believes this evidence, believes this story.
So what happened?
Though
to
the
criminal
claimant
case?
manipulates that he himself the rider, then he claims to be the pillion rider. If the
What
bus,
happened to the criminal case?
My lord,
Criminal case ಏನಾಯ್ತು?
criminal case, my lord, 1 minute. ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ ಕೇಸಸ್ ಬಹಳ ಬೇಗ ಡಿಸ್ಪೋಸ್ ಆಗ್ಬಿಡ್ತವೆ ಇಲ್ಲಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಲೇಟ್ ಆಗ್ತದೆ, ಅಲ್ಲಿವರೆಗೂ ವೇಟ್ ಮಾಡಲ್ಲ, ಟೈಮ್ ಕೊಡಲ್ಲ. ಬಹಳ MEC ಕೇಸ್ಗಳು ಬೇಗ ಡಿಸ್ಪೋಸ್ ಆಗೋದ್ರಿಂದ ಅಲ್ಲಿವರೆಗೂ ಇವ್ರು ವೇಟ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ದೇ ಆರ್ ನಾಟ್ ಏಬಲ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್, ಈವನ್ ನಾಟ್ ಏಬಲ್ ಟು ದಿಸ್ ಥಿಂಗ್.
Whether your driver has pleaded guilty?
No, my lord.
And whether your conviction?
100% no.
ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರ ಕಾಪಿ?
We have produced the FIR, my lord. You will ask me kindly see. Sorry, IMA report, exhibit IMA report, and also you will ask me kindly see exhibit P7.
What happened to the criminal case?
My lord, that I have to ascertain, my lord.
ಮತ್ತೆ you have to find out that, and why you have not challenged. Then your driver has not challenged that charge sheet.
My lord, he cannot challenge it also, my lord.
Why?
Because we have challenged in many number of cases. I can produce a certified copy. When once the charge sheet is filed, you go and face the trial. That's what the opinion of this honorable court, and in the threshold of it, they have dismissed.
Then you have to get acquitted in that case on merits.
That I will ascertain.
Huh?
That I will ascertain.
Ascertain that, because if that is then acquitted.
Then
on
kindly have it
merits,
on Monday, my lord. By that time, I'll get the information, or even Friday also.
all your aspects, what you have now argued, can be appreciated only once.
Sure, my lord. Yes, your lordship is right, my lord.
Request.
I'll try to get the information and try to
released on 22nd.
Please, my lord.
ಅವ್ರು ಹೇಳಿರೋ ಕೇಸ್ ನಿನ್ನೆ ಎಸ್ಟರ್ಡೇ ಮ್ಯಾಟರ್ ಮೆಲಡ್ ಇಸ್ ಲಾರ್ಜ್ ದ ಕಂಪ್ಲೇಂಟ್ ಆನ್ ರೈಡರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಮೆಲಡ್ ಇಸ್ ನಾಟ್ ಈಸ್ ಏನ್ ಬಂತು ಅದನ್ನ ಬೇಕಾದ್ರೆ ತಮಗೆ ಹೇಗ್ ಬೇಕೋ ಹಾಗೆ ಅವ್ರು ಇಲ್ಲೇ ಕುಂತಲೇ ಎಲ್ಲನ್ನ ಅನಲೈಸ್ ಮಾಡ್ಕೊಂಡು ಇದು ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ, ನಾಟ್ ಓನ್ಲಿ ಅಗೇನ್ಸ್ಟ್ ದ ರೈಡರ್, ಈವನ್ ಅಗೇನ್ಸ್ಟ್ ದ ಕಾಂಟ್ರಾಕ್ಟರ್.
ಆ ತರ ಅನ್ಕೊಂಡಾಗ ಕಂಪನ್ಸೇಷನ್ ಗೋಸ್ಕರನೇ ಇದು ಮಾಡ್ತಾರೆ ಅಂತ ಅನ್ನೋದು ಅದನ್ನ.
ಹೌದು 100% ಅದೇ ರೀತಿ ಆಗ್ತಾ ಇರೋದು. 100% ಅದೇ ರೀತಿ ಆಗ್ತಾ ಇರೋದು.
ಅಲ್ಲ, ನೀವು ಕುಂತಲೆಲ್ಲ ಇಲ್ಲ ವಿತೌಟ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್ ಈಸ್ ಸೇಯಿಂಗ್ ದಟ್ ಅದು ಇದು ಅಂತ ಹೇಳಿ ಎಲ್ಲ
No, with your own document I am telling, with your own document IMA report.
Write out.
Your own document, I am telling.
Whether he has been acquitted or whether anything is there
Please, I will
which is
verify.
helping him or helping you.
Please.
Because once
I
there is a charge sheet, whatever he may say, then.
That is not a conclusive proof, my lord.
ನೋಡಿ 22ನೇ ತಾರೀಕು.
ಆ ಕೇಸಲ್ಲಿ BWSSP and also the contractor has been charged, FIR, the criminal case is filed.
All right.
ಪಾಪ ಅವ್ರೇನ್ ಮಾಡ್ತಾರ ಅವ್ರ ಡೆವಲಪ್ಮೆಂಟ್ ವರ್ಕ್ ಮಾಡೋದ್ ಬೇಡವಾ, ಇವ್ರಾಗ ಬಿದ್ದೋಗ್ಬಿಟ್ರೆ. ಅದು ರಸ್ತೆ ಮಧ್ಯದಲ್ಲಿ ಇಲ್ಲ, ರಸ್ತೆಯಲ್ಲಿ ಮೂಲೆಯಲ್ಲಿ ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಇದೆ.
Madam
Much of it.
Srinivas Ashok Patil. And none appears. Released next week.
Appear for respondent number 3 and 4, my lord. Kindly 1 week time may be granted a file wakalat, my lord.
Request of R3 and 4 released next week.
And serial 15.1, my lord, kindly interim order extend.
55.1 alla.
54.1.
Or interim order extended in 54.1. Next date.
I appear for appeal.
For respondent, no. Case of injury.
Climate appeal finance with the company. Date of accident is on 5/3/2018, madam. Appellant was 35 years old.
35.
35. He was doing working as a mason and earning a sum of 18,000 per month.
Earning?
18,000 per month. As per local chart, tribunal has taken 12,500.
12,000?
500.
Taken.
12,500.
Correctly.
Directly taken. In this case, my lord, the appellant had sustained compound fracture right radius, dislocation of the right elbow, deglowing injury to right forearm with wrist drop. He was treated as inpatient for 27 days in Sanjay Gandhi Hospital, and he has undergone surgery.
27 days.
27 days. After complete treatment, there is a permanent disability to the extent of 30% to the whole body. I have produced the present photograph of the appellant, my lord. The same are marked as exhibit P7. After complete treatment, there is no movements in his right elbow and wrist. There is evidence of the doctor.
What is the disability as per the doctor?
30%.
30%.
30%. And also there is evidence of the doctor. He cannot use his right hand and he cannot do any work from his right hand. There is no movements at right elbow movements. Present photographs are produced.
30% to the whole body or
particular limb?
Limb.
Doctor not assess the limb disability, my lord. Only whole body disability is assessed. I have produced the exhibit P7 photographs, my lord. Clearly discloses that there is no movements in his right hand. He cannot use his right hand for any purpose, man.
Yes.
There is a relevant discussion at page 16, para 15 of the judgment. Page 16.
Yes.
Beside, it is well settled that in motor vehicle claims compensation cases, that strict proof of negligence is not required. For foregoing the reasons, I have no doubt in mind to conclude that
you are reading para number 16.
15, page 16.
15.
15. Beside, it is well settled that in motor vehicle claim compensation cases, the strict proof of negligence is not required. For the foregoing reasons, I have no doubt in mind to conclude that the accident in question had taken place because of the accident negligence of the driver of the lorry bearing registration KA 42 8644. From the document produced by the petitioner, easily concluded that there was a road accident and the petitioner sustained the grievous injury in the said road accident taken place because of exclusive negligence of the driver of the lorry bearing registration number so and so. With this answer, issue number 1 is affirmative. In next, and the petitioner states that he was aged 35 years on the date of the accident. Due to the accident, he has sustained a comminuted fracture right elbow joint with avulsion injury. After this accident, immediately he shifted to Sanjay Gandhi Hospital and treated as inpatient and undergone operation. Open rectal lintel fixation was done, and a doctor have opined that injuries are permanent in nature and advised him that he shall not involve in any physical strength work for a minimum period of 6 months. In order to prove his permanent physical disability, he examined one Dr. Prakash Patil, professor of orthopedic at Sanjay Gandhi Institute of Trauma Orthopedics as PW2, and he deposed that in his chief examination that he examined the petition on 6/3/2018. He found the injuries: compound fracture right radius, dislocation of the right elbow, deglowing injury to the right forearm with wrist drop, and he done surgery and radius was fixed for debridement and wound with the square nail, and forearm was covered with the skin graft and discharged the petitioner on 2/4/2018. Since then, he was on follow-up treatment. He lastly examined the petitioner clinically and radiologically on 1/4/2019 and assessed the disability of the upper limb, arm component, hand component, mobility and stability component, coordinate activities of the limb, and he assessed the total permanent disability of the upper limb 30%, and the petitioner needs to undergo one more surgery for removal of implants, for which he has to spend rupees 10 to 15,000. And he produced the recent X-ray photo copy of the case sheet, and which were marked as BP1 and Exhibit R1 and R2. Instead of P series, he has been subjected to cross-examination by the respondent number 1. He clearly admitted that the wound of the petitioner completely healed, and he mentioned in para 4 of the affidavit that 17.3%, 30%, that's a typographical mistake. It has clarified in the cross-examination of the doctor. And witness stated voluntary due to oversight mentioned 17.3 is equal to 30% instead of 27 plus 3%, 3 is equal to 30. And further, he admitted that he did not assess the disability for the upper limb, and he denied other suggestion as per evidence of the PW2. Fractures completely healed and grafted injuries, visible scars appear, but the petitioner can do his regular work without any difficulty. Admittedly, the petitioner did not produce any document to prove his vocation, that is, he doing mason work.
All right, come to that other heads.
And in this case, there is evidence of the doctor. He cannot do any manual work. It has come in the evidence of the doctor.
He was a mason.
He was a mason.
Records idea.
It is photographs.
P7.
Exhibit P7. The above disability is permanent in nature, and with this disability, person not able to do any work, and his right hand from his right hand.
Yes.
There is no
disability is taken at 30%.
30%.
How can it be 30%?
Well, according to the doctor, that is the whole body disability.
No, upper limb.
Upper limb particularly.
In the evidence of the doctor.
How you can assess a disability without coming to the limb, whole body?
That is
all these other three, left, right, left hand and two legs are in order.
Yes.
In order. Only right hand below the arm.
Below the arm, including the elbow joint. There is the movement in the, and there is no movements in the elbow. Up to elbow.
How can that become 30%?
You cannot do straight, brother. It has come in the evidence also.
All right.
He cannot do any work. He cannot hold
All right.
things
What
from his right.
understand is 7%.
7% instead of 30%. In
Some
this,
reasonable something can be taken.
functional disability is to be taken into
What
consideration.
is to be taken?
In this case, the 30% is to be taken into consideration.
Reasonable ಹೇಳಿ ಅಂದ್ರೆ 30% ಹೇಳ್ತೀರಲ್ಲ.
Well, in this case, he cannot do his right, any work from his right hand, that's what.
Can do from his other hand and then 2 legs.
Yes, my lord. Right
Not
hand
under
is,
ECA.
he has lost his right hand.
What was he doing?
He was
Mason.
a mason. He cannot do.
10
In
to 12%
other
is
conventional aid, my lord.
Yes.
Regarding loss, pain and suffering. Only 10,000 award.
Amenities
22.
increase ಮಾಡೋಣ, pain and suffering ಮಾಡುವ.
Loss of amenities.
Food nourishment 27,000.
20 days.
Amenities only 10.
Loss of income later period into 3 months.
In this case, he was inpatient for 27 days.
4 months.
Loss of amenities,
50,000.
pain and suffering.
Yes, what else?
In this case, function, my submission is functional disability is to be taken.
How much should we take it?
At the minimum, 25% is.
Huh?
25% is to be taken.
10 to 12% is reasonable.
After go through the photographs, there is no movement.
10 to 12% is reasonable, Malas.
Record.
But finally, pain recovery has been added. Permit violation. Interest 9% has been awarded. In enhancement amount maybe 6%.
15% but disability.
15% is higher.
By the claimant challenging the judgment and award of the 24th additional small process judge, MACT Bengaluru SCCH 26, MVC 2144 of 2018. The ground of inadequate compensation awarded by the tribunal. The case of the claimant that he was traveling on a motorcycle bearing registration number KA42K8878 as a Pirian rider on 5/3/2018. And when they reached near Yakuli village, Kodihalli Hobli, Kanakapura Taluk, Ramnagara district, a driver of a lorry bearing KA428644 came in a high speed in a rash and negligent manner and took and came onto the extreme right side of the road, dashed against the motorcycle, due to which the claimant fell down, sustained grievous injuries. He was shifted to Sanjay Gandhi Hospital and thereafter where he took treatment as inpatient, underwent open reduction, internal fixation, and advised rest for 6 months. In view of the injuries suffered and disability sustained, he filed claim petition seeking compensation against respondents. Respondents 1 and 2 filed statement of objections, denied the claim of the claimant, including age, avocation, income, and denied the negligence attributed against the driver of the lorry, sought for dismissal of the claim petition. Respondent number 2 took up a plea that his vehicle was insured with R1 and any liability fastened on him would have to be indemnified by respondent number 1 insurance company. Whereas respondent number 1 took up the plea that the respondent number 2, the driver, respondent number 2 is liable to pay the compensation as the driver of the lorry was not possessing a valid and effective driving license as on date of occurrence of accident, thereby committed breach of terms and conditions of the policy. Full stop para. On the basis of materials placed on record, both oral and documentary, and the issues framed, tribunal awarded total compensation of 2,45,264, along with interest at 9% per annum. Directed respondent number 1 insurer to pay the compensation and recover the and liberty to recover the same from respondent number 2, owner of the offending vehicle, this lorry. Full stop para. Being aggrieved by the meager compensation, claimant is before this, appellant is before this court seeking enhancement. Full stop. I have heard learned counsel for the appellant and learned counsel for the respondent insurance company. Peruse the impugned judgment and award. It is seen that exhibits P1 to P10, P11 are the documents produced, out of which P1 to P6 are the police records, which depicts FIR and charge sheet having been laid against the driver of the lorry, which is not questioned or challenged. Therefore, negligence is rightly attributed against the driver of the lorry. Full stop. Para. Now, coming to the question of age, avocation, income, the disability and appropriate multiplier for awarding compensation. You see that the claimant was aged 33 years as on date of occurrence of accident. The appropriate multiplier is 16, which is correctly applied by the tribunal, which does not call for interference. Doctor has been examined as PW2, who was opined disability to an extent of 30%. Permanent disability for right upper limb. But he has not he has not opined disability to the limb and whole body separately. Hence, tribunal not accepting the opinion of the doctor has assessed the disability to be 7% as against 30%. The tribunal has taken the income at 12,500 per month, which is correct as per the notional income chart. Same does not call for interference. Learned counsel for the appellant contends that the claimant was a mason by profession. In view of the injuries sustained on the right hand, it has become immobile and is unable to do any work as a mason, which was his employable status prior to the occurrence of accident. Though the doctor has stated disability of 30% to the whole body, this court is of the opinion that the disability assessed by the tribunal is on the lower side, considering the fact that the claimant was a mason and now not in a position to do any job because of his injury suffered to the right hand. The disability could be taken at 15%. So the same is objected to by the learned counsel for the insurance company. Therefore, loss of future income due to disability change would get modified in the following manner. 12,500 into 12 into 16 to 15%.
3,60,000.
3,60,000 as against 1,68,000 awarded by the tribunal. Para. Towards pain and suffering, 50,000 is awarded as against 10,000. Towards the loss of amenities of life, 50,000 is awarded as against 10,000. Medical expenses of 17,264 is retained. Towards nourishment, food, conveyance, attendant charges, 27,000 is awarded as claimant was inpatient for 27 days as against 15,000. Towards loss of income during later period at the rate of 12,500 for a period of 4 months, 50,000 is awarded as against 25,000. In view of the above, claimant shall be entitled to total compensation of
Future medical expenses. It has come in the evidence of doctor.
Amenities 50,000, suffering 50,000. 5,54,264 as against 2,45,264. Accordingly, I pass the following order. Appeal is allowed in part. Claimant is entitled to total compensation of 5,54,264. Full stop. Claimant shall be entitled to interest at 9% for the amount awarded by the tribunal. Full stop. For the enhanced compensation, interest shall be calculated at 6% per annum. Balance compensation shall be paid within a period of 4 weeks from the date of receipt of copy of the order. Entire amount shall be released in favor of the claimant upon proper identification.
TCR.
Pay and recovery.
TCR kindly.
The order of pay and recover is retained.
TCR kindly be heard. Send back.
Trial court records shall be transmitted forthwith to the jurisdictional tribunal.
Much.
Hearing for R1, owner of the vehicle.
All this
Hearing for
next
respondent
week.
number 2, my lords.
Next week.
Please, my lord.
Appearing for the appellant, my lords.
Mr. Shreyas, next week.
Please, please, please. Grateful, my lords. Great.
Appear for response.
Abubakar Shafi. Deshraj.
After respondent. After vacation.
Specific performance.
Yes, ma'am.
You don't know. Uttilla. You're appearing for so many years, madam, you should start arguing. Martira.
Kindly have it after vacation.
After vacation, you Martira. No. Read and come. Read at request of respondent released after vacation. Summer vacation. Yes, Mr. Kamath. You are Kamath.
Yes.
Was this heard?
No.
Yet to begin.
Yes.
May not be possible now.
Yes. After.
After vacation. After released after summer vacation. Request of both counsel.
Hearing for claimant announcement of case of
26.
23rd month. They have done.
All right. Mr. Mahesh. Oh, Mahesh.
Police, sir. Serial number 34, O Mahesh.
Hello.
Mr. Mahesh.
Yes, my lord.
We'll have this matter on 23rd he wants.
There is some disturbance outside. I can...
23rd, 23.
Serial number 34, my lord.
23rd ಗೆ ಸರ್.
Pardon?
23ನೇ ತಾರೀಕು.
Okay. 30, madam?
ಇಲ್ಲ 23rd.
After 2 weeks, sir.
Please, sir.
23rd. Yes, Mr. Krishna Swami
38.
and Satish. ನೀವು ರೆಡಿ ಇದೆಯಲ್ಲ ಟೈಮ್ ಇಲ್ವಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ Monday, Tuesday.
ಏನು ಸಿಂಪಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಫೀ ಇಸ್ ಆಲ್ಸೋ ಅಗ್ರಿಯಬಲ್ ಅವರು ಬರೆದಿಟ್ಟಿದ್ದಾರೆ ನನಗೂ ತೋರಿಸಿದ್ರು ಒಂದು ಮಿಸ್ಟೇಕ್ MACT ಅವ್ರು ಮಾಡಿರೋದು ಈ ಲೋಕಲ್ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಚಾರ್ಟ್ ಪ್ರಕಾರ ತಗೋಬೇಕು ಇನ್ಕಮ್
ತಗೋಬೇಕು ಡೆತ್ ಕೇಸ್
ಆಫ್ ಡೆತ್
ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಾ ಚಾರ್ಟ್ ಇದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ
ಇಲ್ಲ
ಒಂದು ರೆಡಿ ಮಾಡಿ ಅವ್ರಿಗೆ ಕೊಡಿ
and MACT also has committed a mistake in taking
Multiply.
17 as multiple.
ಎಷ್ಟು ತಗೋಬೇಕಾಗಿತ್ತು
16 hours. 16 hours.
ವಾಟ್ ಇಸ್ ದ ಏಜ್
35 years.
35 years ಗೆ
35, 16 ಆಗಬೇಕಾಗಿತ್ತು.
Yes, ma'am.
45 years.
And 40,000 excessive compensation under conventional head is granted. My learned friend also agrees with that.
No, what about the income?
Income,
Tribunal taking 9,000, Mela. Tribunal taking 9,000.
ಎಷ್ಟು ತಗೋಬೇಕು?
11,000 2017.
ಅದನ್ನ ನೀವು ಬರ್ದು ಕೊಡ್ಬೇಕಲ್ರಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಐ ಹ್ಯಾವ್ ಟು ಪೋಸ್ಟ್ ಇಟ್. Do one thing, you prepare that, give it to him. I list it on Monday and dictate it.
Monday.
What is today's date, madam? We are 16, 18th. 18th.
Yes,
ಆಗ್ಬೋದು.
18th.
Yes.
Released on 18th.
Melody, other than 18th, any day. 19th.
19th, all right. Released on 19th. But only calculation method of this. Only calculation.
48, Satish Shetty.
And released on 22nd, Mela.
48. 48. 22nd,
next month.
Released on 22nd. At request of respondent. ಆಯ್ತಾ? Today, only one. What is your abbreviation name? AM.
After ಮುಗಿಯೋತನ ಫ್ರೀ ಆಗ್ತೀವಲ್ಲ ಏನೂ ಇಲ್ಲ ಸ್ಪೆಷಲ್. ನಾವ್ ಯಾವತ್ ಸೀರೆ ಉಟ್ಕೊಬರ್ತೀವೋ ಅವತ್ತೇ ಸ್ಪೆಷಲ್.